of pictures are they? Thanks, Julie. Hi, Alice. We have more black boxes than we have pictures, but I guess that's to be expected at 4 o'clock on Tuesday afternoon. We have 1 minute to 4. I'm gonna say, Michael Pipta, tell us about your favorite listing right now. Doesn't have to be your own, but it could be your own.
My favorite listing today. I saw one pop up that Jill in our office has listed. Cute little structure. It looks like there may have been some permits on it, but it's freshly painted in a nice color green, sitting in the forest.
Oh, I saw that too.
And it was sort of intriguing. It was nice.
It's in escrow already.
What?
Yeah.
Okay. Well, that's how much of a favorite it was. It's always nice to see some cute little things pop up like that.
Yep. Thank you. Thank you. Okay, now it's 4 o'clock. So let's get started, because I know that time is money and that matters to all of you, but not as much as your clients matter to you. And that's the part of the point of today's conversation. There are, and I'm not going to get really drilled down into the he said what kind of filings that have occurred in these lawsuits. We're going to do an overview of them, and we're going to talk about what the National Association of Realtors is doing. And then more importantly, we're going to talk about what can we do, what's within our control as individuals. So I don't have a fancy PowerPoint. I don't have a lot of colorful pictures. So we're going to just get to dig into this, and hopefully it'll make sense for you. There's 2 main lawsuits. The one that's going to go to trial starting on October 16th, which is this week. That's called the Sitzler-Burnett, S-I-T-Z-E-R, Burnett. That's coming from a group out of Chicago. And then the other lawsuit is called the Moehrl, M-O-E-H-R-L lawsuit, and that's coming to us from Missouri. That one is scheduled to go to court in 2024. And of course, they're watching very closely to see what happens in this lawsuit in, here in October. I understand that there are all kinds of discussions going on to try to settle it before we go to court. But as of last Friday, the National Association of Realtors Board of Directors had an update meeting for all of the directors. And that's why I asked to have this meeting today, there's so many rumors out there that I wanted to try to give you some sense of peace of mind that the whole world's not coming to an end. If in terms of timing, if there's no settlement prior to October 16th, then they'll go to court. No matter who wins, there will be an appeal. And so even no matter who prevails in the October case, which they don't expect it to finish in this calendar year, it should go on into 2024, then the appeals will take even longer. So based on lawsuits of this kind of civil action and this sort of timing, the soonest that there would actually be a decision made that we would have to take action on would be 3 years, and probably more like 5 to 6 years. So that leaves it all up in the air. One of the things that we need to be, as local brokerages or local MLSs, is copycat lawsuits. And there may be other people that will file similar lawsuits at a lower level. Right now, the lawsuit is attacking the National Association of Realtors for obvious reasons. They've got a lot more money than all of us added together, and they represent all of us. So that, that gives them clout, but it also makes them vulnerable. So that's why the lawsuit's been postured the way that it is. And the point of the lawsuit I'm getting a notice that my quality of signal is poor. Can you all understand me? Okay, good. I guess it's just my crazy computer. The point of the Sitzler-Burnett lawsuit is asking, why brokers representing home sellers often pay the commission of brokers representing the home buyers. And in fact, the moral lawsuit spells it out a little differently, that they're accusing us of having conspired to require home sellers to pay the broker representing the buyer of homes. And that goes to the cooperating brokerage agreement that is required through all MLSs by NAR. That is a rule of NAR. The Anywhere Corporation, which many of you know to have, you would be more familiar with the expression company name Realogy. Realogy is who we all knew owned Coldwell Banker, Century 21, and Better Homes and Gardens. Well, that Realogy became Anywhere. So some people are concerned that there's more real estate firms involved in this lawsuit than not. Anywhere has negotiated a settlement with in this lawsuit, but their settlement has not been released because it has not been accepted by the judicial system yet. So we don't know the details of that. There are some rumors about what it is in the press, but I'm not going to talk about rumors today, just to kind of make our lives a little more simple. So the nuts and bolts of the Sittler case, which became a class action suit back in January, which allows a lot more people to be involved. The plaintiffs have already had one early advantage. The court has ruled that the case can proceed on a per se basis, meaning that the alleged actions are so likely that to have been anti-competitive that they will be treated differently in court. That is one of the weak points of the National Association's case. But the National Association is standing on the grounds of consumer protection, and that they'll be presenting a strong consumer protection case that should dilute that the per se basis strength. So that's in a nutshell what they're going to say about that. I'd rather at this point go into talk a little bit more about what can you do. How many of you currently use the buyer's representation agreement with all your buyers? I see one hand out of the 57 that are on the screen. There's some brokers in charge on this call. Do any of your firms require your agents to use a buyer's agreement with buyers? No. That's probably going to change. I've got a couple of chats coming in from people that I didn't see hands from, that they're saying that they've just started using it. I'm going to ask Julie Ching to speak to this subject right now. Would you mind doing that, Julie? Unmute. There
Sorry,
you go.
yeah, okay. Well, I think I can tell you why I use it, because I got burned a couple of times too many. And then once you've invested like a couple of years with people, and then they go use somebody else that they walked into an open house with or something like that, it hurts. And so I just went, it made sense for me to do it. I've only been turned down once, and I've sold over $200 million in real estate. Not all buyers, of course, but about half. And only one person said no. I would say that if you have an opportunity to take the accredited buyer's representative class, it is worth its weight in gold. I've taken it a couple of times, and there is a really good resource. I hope she's still here. Her name is Beth Holiday. She lives on Maui. She's an instructor, and she presents it in such a way. It's like, why would you not sign this agreement? Okay, so basically some of the nuggets from her class are that, we're members of NAR and we're held to a higher standard. We have a code of conduct that we have to follow. And part of that code says that every single agreement will be in writing. And that includes your employment contract with the buyer, right? And you can point them straight to the code. Like, I'm required to have this. This is going to, and here's why. it protects both of us and make sure that we're on the same ground, if you will. Level playing field. It spells out what I'm gonna do for you, and it's gonna spell out what I expect, you know, from your side, including compensation. Right? And so this is how it works. Usually they read through it, and I just let them know it doesn't mean that you have to buy anything. It just means that if you do that, you know, this will go in and I'll be representing you. And it's much like an attorney, right? Attorneys they provide representation. It's the same thing. And it has been a bug up my you-know-what for how many years that buyers, I feel like, haven't been treated fairly like sellers. We require a listing agreement to list a seller's house. We should have a contract that you're listing a buyer. You should have one for that. So anyway, we do use them pretty much exclusively. Like, yeah, I mean, I can't think of a buyer that we represented that we haven't in over 14 years. So, and I was using them before then. But anyway, I'm a big proponent of it. And I think, this is definitely one of the scenarios that can come out of these lawsuits, is that, you know what, if a seller's not going to be forced or urged to cooperate with compensation on the buyer side, you're going to be working for free if you don't get these buyer's agreements. So it's coming down the pike, and I highly, highly, highly recommend you, read it, understand it, get educated on it. And if you can get a class with Beth Holiday on Maui, I'd go for it.
Thank you, Julie. I know that Hire is offering the ABR course on buyer representation. I'm not sure if you can still sign up. Here I'm getting Melanie's chatting in right now. You can still sign up. So and it gives you 12 hours of CE credit. So that's that's better than a twofer. So look in the chat box for that. I also saw a question in the chat box from a skilled broker on how do you get the commission paid. It's just a paragraph in the buyer's representation agreement. I've been using it, probably not as strongly as Julie, but I'd say at least 80% of the time. And I have collected commissions with no issues. I even had a situation where there was a cooperating brokerage fee, but it was lower than I had thought it was going to be for a crazy reason that we don't need to discuss today. And when my buyer, I didn't know about it, but my buyer heard about it in the grapevine of the community. And they went to escrow prepared to put in more money to pay the difference when I didn't even ask them for it. So I think it has, it's about that, your ability to offer the level of service that they feel they should be compensating for. I guess, Julie.
I would just add that, it's no different than a listing contract. So when you open escrow, I always provide a copy of the buyer's agreement so that they can see that they've signed it. I mean, it's a legally binding contract. So that's how you get them to pay. And there are ways to go about it. So if in the instance where Mary said that she thought the cooperating amount would be greater, they only have to pay the difference, right? And then there are ways where you can actually legally ask for the seller to reimburse the buyer X amount for non-recurring closing costs, and in section Q, and that's totally legal. And that way you get compensated fully, and it works.
There's another question about will the lender have to qualify the buyer knowing the buyer is paying commission to buyer's broker? They'll need to have that cash available. Yeah, sure. So,
and they can oftentimes wrap it into the loan because it is a closing cost, just like escrow and title and so forth.
It depends on the kind of loan that they're getting. I did some research on that aspect of being able to finance the commission, and it depends on the kind of loan. Of course, FICO scores, all those things that come into play on any mortgage would also come into play there. But that's really when the worst case scenario out of all these lawsuits is that every single transaction, you will have to negotiate the commission. And what was brought up in we have listing agreements now that state what the commissions are going to be. But if we're negotiating our buyer's commission in every transaction, it's only going to be a minute before we're going to be in a situation where we're negotiating every seller commission as well. So this, if you think you can sit on your laurels and think, well, all I do is list, really, it won't matter. The world's changing. That we need to face that reality. We don't drive the same kind of cars we used to drive. We don't power our homes the way we used to power our homes. Why would real estate be sold the way that it was sold 100 years ago? So we just need to open our minds and be educated and be prepared. And that's the, you know, and make sure that we're speaking to the value. Melanie, would you put the 179 things that we do into the chat for everybody, please? I think that some of you as brokers these are things you've been harping on your agents to, especially newer agents, to understand, but these are the 179 things that we do in pretty much every transaction. And so, you know, if nothing else, put this into your listing package of what you're going to do for people when you, when they hire you. But it's a downloadable document that you can, as a PDF, you can use in any number of ways. And that's really where we need to take this, is how do we posture ourselves? How are we going to explain to people what our value is? And not just because my broker said I have to, you know, that's not going to get you where you need to go. So thanks, Melanie. There's sorry, I'm stumbling, I think of the right title for it. There's an FAQ out by NAR that, so why can't commissions be included as part of the mortgage? And one of the things that came up was that investors may not, because there might be so much variation in costs in a community, some investors may not buy mortgages from that area or that kind of loan. When I asked loan officers about how much they were concerned about that, they said they have to always look at what their investors are interested in purchasing. But thanks, Melanie just put the FAQs in there for you as well. So that was one of the issues. Of course, there's no set amount of commissions, whether it be for a seller or a buyer. All commissions are negotiable. That's the whole antitrust point. The other thing I thought was interesting was that's been being discussed in these lawsuits is that no other country in the world is organized the way the National Association is and the way our multiple listing systems work. I have clients that live in England, and they moved back and forth between Manoa and Oxford a couple of times in the 27 years I've known them. And every time they come back, they're like, oh my God, Mary, it's so much easier to buy real estate in America. You know, in England, you have to know where the real estate offices are. And even today, in the computerized world that we live in, you still have to walk up and down the street and know where the real estate office in England is located, and look at pictures pasted to a glass window, you know, a storefront, and then go inside and say, I want to see the picture in the second picture in the third column. You know, I want to see that house. They don't have any, they have no buyer representation whatsoever. You only the sellers are represented. And what they thought that we as American realtors should warn them about when they bought property in America and then go back to the other country they've come from is to caution them that, remember, it's not going to be like America. You're not going to be represented. So keep your guard up, because you're not going to be safe in England like you were in America. So I thought that was funny. Let's see, somebody asked me a question. Kathy, if that one important thing is for us to stop saying the seller pays the commission. I mean, we've had that semantical argument for years. If the buyer's buying the house and providing the money for the house, maybe it was always the buyer paying the commission in the first place. What we need to stop talking about is having to have conversations about it other than the employment agreement. The listing contract is an employment agreement. Julie stated it clearly. The buyer's contract is an employment agreement. You hire someone to work in your office, you have an employment agreement with them. We've shot ourselves in the foot in many ways by not framing this correctly. One of the FAQs here that I thought was interesting is, why are MLSs needed when you can find listings for homes in so many other places online? Well, all those other online places got them from the MLS. If there wasn't MLS, there wouldn't be all these other things. So, you know, it's kind of humorous. I don't know what else, what the other one was. So fair housing, the Department of Justice, the National Association of Realtors went into arbitration with the Department of Justice last year, and we had an agreement with the DOJ, and everybody went home for the Christmas holidays in 2022. And when they came back to work in January, the DOJ said there'd been some shifting in people in positions apparently. And they said, you know what? We don't want that. We don't want to do that agreement anymore. Never mind. NAR said, you can't do that. We have a deal. We made an agreement. And, you know, we've already sent all of our employees and our members down a path to make this happen. So the court has come back and said that the DOJ has to stick to the, you know, you can't just change the agreement because you change the drapes in your house. So, and that part of that DOJ agreement was already in effect here because it was the clear cooperation. And the clear cooperation, there was a lawsuit over clear cooperation, and NAR came out on top on that because it was all about consumer protection. So let's see, will the HAR listing agreement be rewritten and changed in coming months to reflect items on this issue? It's hard to say. You know, the forms are always being changed to tweak when laws change and circumstances become different. Specifically for this lawsuit, I'm not in a position to answer that because I don't think the lawsuit will be settled in time, you know, that soon. They're saying 3 to 5 years before all the appeals are completed. So whether or not a form would need to be changed, I don't know. But we may need to keep our minds open to the fact that we might see more frequent changes in forms as things evolve throughout a trial. It might be prudent on our part to see that a direction, you know, some kind of trend that's occurring in the trial, that we want to do something smarter. So I think especially those of us that are brokers, we want to be open-minded to that occurring. Let's see, what was the other one? Our National Association legal team asked us to support what NAR's approach is, and that's to be proactive in our storytelling, that in our communication with our clients about how things are paid for, to make sure that we're selling our value. When clients, especially if they ask a question in a more challenging way than just curiosity way, be thoughtful in your response. Don't be knee-jerk that, you know, well, I'm worth it. Of course you're worth it. We all know that, but you want to make sure that your behavior is showing that worth, that the things that you do for them, that's a part of your thoughtful response, that you can, you know, that you don't have to explain things you might do in the future just because they've questioned you, but hearken back to what you've already done for them. You know, we've looked at these properties. I've negotiated for you. Maybe we canceled an escrow because it wasn't in your best interest. I've still not been compensated. I'm still here helping you. You know, those kinds of things are meaningful communications. And to look at that 179 ways that of things that you do. So that is really, was there anything else I was supposed to cover? Just that there was one statement I thought was interesting of why sue the National Association of Realtors, and one of the plaintiffs felt that they claim it's that our being required to have a cooperating brokerage fee is a violation of antitrust laws, and that it inflates the fees paid to buyers agents, by requiring the listing agent to compensate the buyer's agent. And they had a schematic that showed that they had a theory that they were showing in this schematic that if buyer's agents had to negotiate independently on each transaction, it would ultimately lower the buyer's agent fee to be, and that they used an example number that I don't want to repeat because I don't want any numbers in this conversation, but it was the number they were saying that currently the standard, which we all know there is no standard, but they were using that expression, a standard, and that it would be about a third of that standard. So, who knows? We all have to have value, and we have to be able to sell our value. So, there's the latest updating in forms right now is Ashley just posted it for you. The counter offer has been changed. There's the post occupancy agreement is new. A lot of focus on property management. Those of you that do property management will probably really appreciate all the effort that went in this past year on that. And I'm not sure if any of you did the beta testing. The seller's disclosure form is now fillable. Yay! You don't have to print it out and reload it up. And there's a new form coming out, a sight unseen for rental property. So I'm still just nervous as all get out whenever anything is sight unseen. Gary, could you imagine Penny Bradley letting us do sight unseen back in the 80s when we were working for her?
Nope, would not have happened. It's still not a good practice, but
No.
in these times, it'll happen sometimes.
Right. Does anyone have any questions or anything specific that they would like us to go deeper into? I don't see any.
Mary,
Yes,
I
Joy?
got I don't know what you call it, a private message from somebody in the group.
Okay.
I won't mention names just in case they don't want to know. But this person was asking, thinking her company needs to have a seller amendment to the listing agreement, and asked if I was going to do that. And my response is no, because we are encouraged to use the current HAR standard forms always. And if there is a change that needs to be addressed, HAR will come up with a form immediately, just like they did for COVID. Just, you know what, they're on it. They'll take care of it. I wouldn't worry about it. I did attend another meeting similar to this at 1 o'clock today, and I do have some notes. I want Mary to finish with hers, and then I'll just bring up a couple of, possibilities and see what you guys think.
Go ahead, Julie. Let's make it make more of a conversation out of it.
Okay. They also talked about, doing real estate abroad is like, I don't know, trying to nail jelly to a tree because it's not organized and you don't have representation and all kinds of things. So it appears that we do have the best, real estate model in the world, which is great. They also said that our commission is double what it is in other countries. So I don't have the source on that, but that's what was said. This worst case scenario, if NAR loses, worst case scenario is that sellers can go all the way back to 2014 if you were a seller from 2014 to now, because this lawsuit was filed in 2019 that we're talking about. There's 5 years that they can go back, statute of limitations. So anybody who bought 2014 till now can jump in on this bandwagon in the class action suit, and they could be coming to, worst case scenario, get their money back, right, for the commissions that they paid. Probably not very likely, but that's a worst case scenario. Some of the challenges that were discussed with the lawsuit is that the jury pool is going to be restricted to people who have not owned a home since 2014. Think about that for a second. who's going to be the jury that's going to determine the fate? It's going to be people who don't know real estate. It's going to be renters. So that's a little scary. They also, a juror cannot be a member of NAR. I think they could not have been a member of NAR from 2014 to now. So yeah, we're essentially going to be dealing with renters as jurors should this go to trial. Best case scenario would be that there's a settlement. One of the people in the last discussion said she was involved with a lawsuit that involved General Motors, and she said, you know, they had a settlement and some things that came out of it were actually really good, and so they changed the way they did business. And I think this can, you know, follow that suit as well. Like Mary said, we've been doing it this way for forever, right? And sometimes change is necessary. And so there will be some things that I'm sure are going to come about that it is going to change our industry for the better. And hopefully, you know, it works out in a settlement. Some of the challenges is that cooperation will be optional. So a seller is not going to be required any longer to offer compensation to the cooperating broker. Some people in another lawsuit said, well, they'll offer $1, right? So essentially there's no compensation, but we're meeting the NAR rule that says that you have to cooperate. If the other party is successful in the lawsuit, they're entitled to treble damages, so 3 times. That's what that means. That's a lot of money. And if sellers come after you, it was presented to us that, you know, some people are thinking, well, I'll just get out of NAR, so I'm not a part of this. Well, guess what? If you do, you lose your representation from this big block that has had your back for all these years. And you're going to be fighting these people with your own attorney, paying your, you know, for your own attorney, and your E&O, and no other insurance will cover it because it's antitrust. So think real long and hard about that. One of the likely scenarios that was presented is that NAR will settle with these lawsuits for about between $2 billion to $4 billion. That was a most likely. So be prepared for dues to go up. And they said about $1,000 to $3,000 per member. And so I don't know how Mary feels about that. I'm just presenting the information that I got today. And you know what, $1,000 or $3,000 even, you could have an attorney for about a week or 2, maybe, you know, so you got to choose your battles. And NAR has been very strong, and I'm an advocate for NAR. I think they're worth everything. One of the other most likely outcomes is that a buyer broker agreement will be required. And we talked about that earlier. I think it's a good thing. Why do we not treat them equally like we do a seller? That's been my beef for a long time. There's a 50% chance of clear cooperation going away. And I won't bore you with my opinion. Dual agency may very well be banned, because if you have a lot of sellers, I can pay so many bananas or less bananas if I don't compensate, you know, the cooperating brokerage. Most people will go, oh, hey, then, you know, they confuse saving money with making money, right? That's another conversation. But so if you can't do dual agency, and a lot of us here have done it very successfully for a really long time, and if you can't do it and your seller's offering a small bunch of bananas instead of twice the bananas, then be prepared to turn buyers away or refer them out, because you will be taking on the risk and the liability of representing them and getting zero in compensation if you don't have a buyer's agreement in place. So yeah.
Thanks for sharing, Julie.
Huh?
Thank you for sharing. I'm sorry, I thought you were done. Go ahead.
Oh yeah, no, it's just, you know, they brought up, you know, so what's the point of doing an open house? Well, to expose people to the home so you can get it sold, yes. And it's also a huge source of lead generation for agents. And the new agents that are out there right now, we were all there. We were all new agents before. And where did we start out? I bet you 99% of it is represented a buyer for the, our first transaction. And so if you don't have the skill set and you're not using the buyer's agreement, you may be hurting, and they think it's going to weed out a lot of these, newer agents with less experience. And so anyway, that's all I have. I'll quit hogging.
Thank you very much. To Julie's point regarding NAR settling or whatever dues increasing or anything like that, at the board of directors meeting that they held last Friday for us, their instruction right now is to not settle. They're answering questions that regarding any settlement agreements that have been presented or any thoughts, but there was nothing substantial had been presented to NAR to work with at this point in time. So as of last Friday. Ivory, you got your hand up. I wanted to get your question.
Thank you. I have a question and a comment. I guess my question, and I might have missed this, is has NAR ever been the recipient of a class action suit like this?
Not of this dollar amount size, and nothing has come after this aspect of our organization. There's been other lawsuits where we've been a friend of the court in other situations. There's a recent lawsuit in Missouri that the National Architectural Association brought, saying that this particular office in Missouri had no right to be providing floor plans in the MLS because they didn't own the floor plans. And the architects that were involved wanted compensation. Ashley and I were trying to find the result of that lawsuit today before we were preparing for this meeting. And what we were told is that it went away, but we don't know where it went away to. So we'll have to stay tuned for a future meeting on that. But that was another instance where NAR, stepped in and said, wait a second, you're talking about floor plans of homes that were built in the 1920s. The architects aren't even alive, even if you wanted to ask for a release. So that's, part of the benefit of being in an organized real estate situation is having that big brother, so to speak, to fall back to.
Thanks.
So
and I guess a follow-up would be, what groups are discussing this? Would that be the Government Affairs Committee that's naturally discussing this? Are there any other groups that are getting together to just discuss this lawsuit or things similar to this on an ongoing basis?
The lawsuit's being managed by the legal department of the National Association of Realtors. And because it's of the magnitude that it is, there's kind of a special task force from people, not just any one committee. That are working on it. So
okay. And my comment was, maybe don't make the mistake of trying to print that 179 things, because I started at the beginning of this meeting and it's now printing number 60. So just be careful if you do that.
Oh dear, mine's only 7 pages long.
I don't know what's going on. It's taking a long time.
Oh dear, Ivory, I'm sorry.
No biggie. I'm happy to do
Thank
it.
you
And
for the caution.
Yes, I'm just warning anyone. It's going to take a bit of ink.
Okay. Does anyone have any other thoughts or comments or questions?
I have a question if you can hear me.
Sure, Stefan. Go ahead, Stefan.
Maybe kind of a statement / question. So if I'm a seller, it's not like I have only one option nowadays. I have multiple options, right? I can put a sign in front of my house. I can list my home, as a for sale by owner. I can go on multiple websites and put my property on some of the most active and popular websites. I can hire an NAR agent and I can negotiate the commission with them. I can go with a low cost MLS NAR agent. There are so many options, and then I can sign a contract with them and we all agree on the commission. So it's not like there is only one option for them and they're forced to sign, a 6% or whatever. commission. The sellers do have options in this market today, so it's just interesting.
You're very right, Stefan, and that's been pointed out by NAR, is that we always contend that commissions are negotiable. There's, you know, I know an agent that if the parties are disputing either their real estate ownership or their marital status, then his commission is completely negotiable at twice the price of any other transaction he does. So, you know, that's his business decision. We all have that right to do. There was kind of a follow-up here in the, it was asked if we know of it. None of the plaintiffs are from Hawaii. No, the plaintiffs are all centered in the Midwest currently. They're all in the Midwest at this point in time. Ivy, do you want to take your hand down or you have another question? Okay, thanks. That's really all that I wanted to cover. I didn't want to get caught in, I didn't want to go into the, I didn't finish my thought on, at this point in time, NAR is not, has not given any instructions or any credence whatsoever in any budgetary fashion to look at a dues increase for this particular reason. That is the fact that it's being discussed in any other seminars. That's the presenters of that seminar. It's the people, there are source information out there, but none of that is coming from NAR. The Budget and Finance Committee of NAR, the treasurer, no one is looking at increasing our dues to pay for the lawsuit. And we have sufficient budget currently to pay for the legal team that we are using to take care of the matters at hand. So there's no dues increase for that purpose either. It can get messy with all the tax write-offs, many claim for closing costs and expenses. Well, you're right. And that's something that we'll need to, the people that teach the good tax seminars to us, the Chris Birds and David Knoxes of the world, those are realtors in our industry that have that specialty that bring those educations to us. So you're right. And then it'll just be another tool that we provide is by making that information available to our clients. If there's going to be a change in what they're going to write off or what their CPAs need as information. Kapono Pa has his hand up.
Hi, Mary. Thank you. Kind of related, but kind of not. I just wanted to get a feel from this group, whoever wants to chime in, but there was a proposed revision that came out from Standard Forms in regard to the listing agreement recently that appeared to not make general excise taxes optional. And I was wondering if anybody else caught that and if they had the same feeling that I did, in that kind of seems a little antitrust for a state association's worth of brokerages having general excise taxes on every listing agreement without the option to have a checkbox next to it, or I suppose you could cross it out, but the perception would be that it's always collected.
I can't speak specifically to our current listing agreement, but I can tell you that when Governor Cayetano was the governor and Ray Kamikawa was his tax director, Ray Kamikawa was the tax director that came after realtors for not paying their general excise tax. And his opinion as the tax director and a tax attorney now in private practice, I saw him not long ago and he was still of the same opinion, that the tax it's a professional tax that every other profession pays. Why on God's green earth are the realtors not already charging it? So that's just for background purposes. And
Thank you for that.
While someone else is talking, I'm going to quickly pull up zip forms and look at the listing agreement. Obviously, I haven't had a listing recently. Darn.
Yeah, sorry, it's not the current. It was a proposed. It came out
Oh.
in the Friday emails from the state association.
It's the one that's up for review.
Yeah.
Okay. Well, then Kapono's put us on notice if we have an opinion about it. Julie.
I have an opinion.
No.
I always have an opinion.
No.
Suzanne has an opinion too, I'm sure. She's just being quiet. But yeah, you know what? Another thing that's irked me is like it talks about compensation. Our compensation is however many bananas. It's not bananas and tax, because we're not benefiting. That is, we didn't earn that tax. We have to package it up and send it to the office. So it's not compensation to us. It's a tax. So anyway, my 2 cents worth. Currently I included under the special terms so that it is in there. But I don't wave a flag in front of it under the compensation paragraph. For that reason. So I'm glad to see that it's going in, because I agree with Mary on this, that it's something we have to collect and pass on. I think you're muted, my friend.
We can't hear you, Mary. Are you saying me?
I'm sorry, Wailana.
Oh, great.
Wailana, your hand is up. Did you mean to speak? Wailana, we can't hear you. We're going to let you work on your audio, and I'm going to go to Ivory.
Okay, sorry, one more. So, is it possible we will move forward the way we have been now, or is it guaranteed we will have a change?
Well, there's nothing guaranteed.
What do you mean? This is life.
For right now, you should plan on continuing to do business as you're doing it, but we would highly, highly encourage you to add a buyer's brokerage agreement to that business model. And even if I've had clients who refuse to agree to pay any commission, but I still ask them to sign the buyer's brokerage agreement. I just cross out that paragraph and they initial it. And that's because I want them to know what it is I intend to do for them and what it is I ask back from them.
And in the compensation box, would you put as per MLS right now?
I just cross it out. I just take it out of the conversation in the buyer's brokerage agreement.
Excellent.
And I think I did it in three contracts in the last 20 years.
Great.
So,
Thanks.
and did Wailana get back? Did we lose Wailana? Tony, Julie, you're going to be busy. Lots of people are asking for stuff from you. In the interest of as time is money, I was trying to stick to a half hour and we're already at 46 minutes. Does anyone have any other thoughts? And they can be along the lines of what Capono brought up. It doesn't have to be, commission oriented specifically in that sense, but if there's something that's for the greater good of this group, we'll be happy to hear about it. Melanie's put one more document in the chat for you.
Say, Mary?
Yes.
Hi, this is Catherine Lambton.
Hey, Catherine, the great
You look
mediator.
good. This is a multi-layered question. It might not be appropriate, but it's blowing in my mind to say this, okay?
Okay.
The commission with the GET, that commission gets divided a bunch of ways. So I have this ongoing argument between John Petrella, my broker, okay, John, right? Between John and my MBA manager. And John says, collect the GET. And the MBA guy says, you're an idiot. Don't get the GET. And I'm torn, but I understand that the entire state has a progressive multi-level tax. So we pay 4 and 4 and 4 and 4 and 4. So if we're going to have 4 or whatever it is now, 4 and 100 million on the commission, right? Then that gets cut with my broker. And then he cuts me a little piece of it. And then I'm taking the gross and paying the 4 on top of that. So aren't I adding a layer, yet another layer of the progressive tax by running that GET through all those systems?
But I think it's like Julie said, more bananas at the top is still going to end up with more bananas later on. So might as well take them all, take more.
It's a pass through.
Yeah,
It's a pass through tax.
Yeah, if your broker pays tax on the whole thing, you don't have to pay tax actually. Whereas most brokerages don't pay tax on your portion.
Ah,
Yeah, it depends on how it's organized, how you'd have to speak to John about how that's, if he's paying on the whole, then you don't need to pay on. But you are
interesting.
correct, and that's why we're allowed to, right now it's 4.5 in the county of Hawaii, and so they collect 4.712. Because the law does allow you to collect
Correct.
the tax on the tax. And that's why, we always argue against increases in the general excise tax, because the little guy gets hurt the most, but that's a different meeting.
So this just falls under the heading of the regular tax process
Yes,
in
ma'am.
that sense. Okay. All right. Well, I don't know if that'll settle the argument, but I'll do my best. Thank you.
Good luck, Kat.
Mary, I have a comment, going back to the commission's, discussion. And I would like to take a, unofficial poll. Is anybody here getting kickback, from clients? Particularly sellers that are like, oh, well, they're all about cutting commissions instead of making money. And they don't understand that cheap is not good and good is not cheap. And I'm just curious. Yesterday, or the day before, I got what do they call it? Residential. It's because I have a CRS thing. It's a referral network. And so I got a lead on this seller client. You guys, I can't make this stuff up. It's hysterical. And she writes like this huge page, telling about all of her property and all this. And it's leasehold, Kamehameha Schools, Bishop Estate, leasehold, Napapo Road, all this going on, da 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 da. And then so she goes through all this, and at the very end, she says, and I will not pay more than 1.5 bananas to the listing agent for a leasehold property. And she valued it somewhere between 600,000 and 700,000. And so I promptly declined that referral. Oh, because the referral company too will take 30%. And I can talk about that. That's just how those are. So anyway, it was more of a headache than anything. And it seems like it's coming up in more discussions, at least for our team. And I wondered if you guys are experiencing that as well.
Okay, I see Stacy's question and Gary has his hand up. Let's do Gary, and then we'll go to Stacy.
Thanks, Mary. Yeah, it's interesting. Partly what I was going to talk about is along the lines of what Stacy is alluding to there. Obviously, being with Coldwell Banker, we have also, supposedly that's part of our settlement. So I'm not sure how that's going to shake out. We really haven't had discussions. Couple of points that I wanted to make. First, I want to personally thank you. You have, for the, probably we don't want to say how many years you and I have been in the business. If Tracy was still here, we could make it longer, but I don't see him on this one. So thanks for always being part of the ledge and keeping us posted on this stuff. There is so much going around that, rumor, social media, of course, just compounds it. But the point I wanted to make besides that was when we start talking about ditching NAR, I think we need to remember very carefully that NAR is a lot more than a commission. This is how you guys get paid kind of a deal. The private property rights in this country are what they are, and as safe and secure as they are, because NAR has been such a vocal and strong proponent for 100 years. We would not have the same, and there are plenty of people out there. Look at the states or the cities at least that have rent controls and things like that. There's a lot of people that would like to take private property rights and kind of take them to, well, other places, shall we say. Won't put names on them. But I think we need to remember that, NAR has not ever been perfect. None of us are. None of our organizations are. They have their warts. They have their problems. They work on them. They get fixed. I hope people don't start giving up on NAR just because someone has said, oh, you can do without doing that, because you're going to lose a lot if you aren't part of NAR. And that I didn't mean to make that sound like a rah for NAR. I get grumpy at them sometimes myself and some of the stances they take. But I'm very happy to see them fighting this. And I hope they fight it hard, because we got an awful lot of things going for us against these people that are running this case. This case is all about making some lawyers money. The individuals who are in this class action are not going to make anything. And we all know that. So I will sign off. Thanks again, Mary. Appreciate it.
Thank you, Gary. So Stacy's question was that how to handle the form. So your standard form, the first page, it said, there's a box. Seller is a member, buyer is not a member. Whatever the case is, it's just a new question we're going to put in when you call and ask, is the property still available? Are you a member of NAR? I need to know to fill out the purchase contract correctly. It's just as simple as that. I think that can be handled very, simply. And with that, I saw Stefan, but then he went away, and now Wailana's got, let's take Wailana because she tried earlier. Go ahead, Wailana.
Thanks, Mary. I hope you can hear me now. Okay, so my question was more for clarification. The lawsuit, is it one lawsuit or is it several, in that, NAR is fighting one, or is NAR supporting Anywhere and, collectively fighting the same lawsuit?
There are two lawsuits active right now. The one is going to trial this week, and the second one is scheduled for 2024. The NAR, there are no lawsuits specific to the antitrust aspect that have an amicus brief or anything out on that I am aware of. And we talked about that at the Friday Board of Directors meeting. And just to kind of clarify, Gary was giving me kudos from a legislative arena. Right now I'm wearing my hat as the Lance Owens and I were appointed to be the NAR directors for small and medium boards in our state starting last year. So Big Island benefits that just coincidentally that we both happen to be on Hawaii Island, but we represent the small and local boards for the whole state of Hawaii. That's everybody but the Honolulu Board of Realtors. So all the neighbor islands. And that's why I asked to have this Zoom time, because I wanted to bring the board meeting forward to the Hawaii Island, my Hawaii Island friends. So there are two lawsuits, Wailana, currently.
Thank you. And NAR is involved or helping with both, or just the one?
The NAR is who is being sued in both. The lawsuit
Okay,
is
so
against the National Association of Realtors.
Okay, and then Anywhere is named in one,
Yeah,
in the other.
right.
Okay.
Anywhere is part of that, yes, and Anywhere has come to an agreement.
Thank you.
Gary,
There's
real
a different
quickly,
lawsuit in the,
I'm sorry.
sorry, excuse me, Gary, there's a different lawsuit that occurred in Rhode Island, Connecticut area that had to do with MLSs that was specific to Keller Williams and some other MLSs. NAR did an amicus brief in that, but it was not against NAR. They just did a friend of the court communication in that, and that that has more to do with MLS than it has to do with commission. Go ahead,
Thank
Gary.
you.
Yeah, the comment I was going to make, and correct me if I'm wrong, there were, besides NAR, there were 4 other plaintiffs. That was Remax, Anywhere, Keller Williams, and Berkshire Hathaway, Home Stores or Home, whatever it is, I can't remember. So it looks like at this point, Remax and Anywhere have settled. Keller Williams and Berkshire Hathaway are staying the course with NAR. So those 5 plaintiffs, or I mean, defendants were the ones that were named, is my understanding.
I believe you're right. Thank you for that clarification. I should have put that up front.
My understanding too is that the Sitzer, Burnett one,
Mhm.
those are like the sellers that have come together to sue NAR because they don't feel like sellers should be forced to pay the cooperating brokers commission. And I'm reducing this down to layman's terms because there's a lot of stuff and we can go off in the weeds and make it really crazy. So that's the gist of that one. The other one, the moral one, is a buyer side. The buyers are suing NAR because they feel like, you know, they're paying for the commission themselves anyway, because it's factored into the price. You wouldn't have, I think Mary touched on this earlier, right? You wouldn't be able to pay the agents if it weren't for me, Ms. Buyer, coming in to buy this with my cash or my loan or whatever. So there's a seller suit and a buyer suit. If that helps, you know, separate it a little bit.
Thank you. It's now 5 o'clock. And I'm going to make a lot of people mad if I don't say bye-bye. Feel free to contact me individually or send a message to Hire or to War if somebody needs more information from their local association. Would like to try to make sure we feel, I think that education gives us confidence and we can be better professionals if we have confidence. So, okay, go sell something.
Thank you.
Thanks a
Ivory,
lot.
I've got a couple dresses for you.
Thank you, Mary.
I'm ready. Thank you
Thanks,
so much.
Mary. Aloha, you guys.
Bye, guys.